if you just say that whatever the law is becomes good, then there's no such thing as a bad regime. And Nazi Germany is no better or no worse than the United States of America. And we all know intuitively that's not correct.
John Eastman is the Henry Salvatori Professor of Law and Community Service at Chapman University School of Law. Before that, he was Dean of the Chapman University Law School, and somewhat before that, he was a law clerk for Justice Clarence Thomas on the U.S. Supreme Court. He's also a senior fellow of the Claremont Institute and the director of its Center for Constitutional Jurisprudence. John, welcome to The American Mind.
Thanks, Charles.
You have been involved in educating young lawyers for a large part of your life. You yourself, of course, have a law degree, but you also, curiously, got a PhD along the way. Do you just like to collect degrees, or was there some reason why you insisted on two?
Well, I remember a set of coffee mugs my mother gave me at one point. It says, you have a BA and an MA and a PhD, now all you need is a JOB, hence the law degree. The PhD came first, and in my senior year in college, I was taking a class on Jefferson's thought, and came across a letter he wrote to his nephew. Thinking about a career in the law, and Jefferson advised him before he studied the law, he needed to study Montesquieu and Locke and Hume. And, in other words, study political philosophy first, because the law is a tool toward an end, and you have to know something about the end that you seek in order to effectively use the tool of the law.
So you think that the PhD made you or makes you a better lawyer or a better law professor?
It makes me both a better lawyer and a better law professor, because you understand the foundations of justice that you're seeking to implement through the law.
And does that point to a gap or a lacuna in the average young person's legal education today who's not getting a PhD?
Not just the average, but almost universally. Most of the law schools do not provide that foundation, and they're not getting it before they come to law school. And so we have, as it were, foundationless lawyers who don't understand the purpose of the law or the notions of justice that the law should seek to acquire. And it becomes something much more malleable than, for example, the Constitution was taught in constitutional law classes, and without even the Constitution appearing in many of the constitutional law textbooks. It had become passé. My own textbook, we have the Constitution in it, but we also have the Declaration of Independence in it.
Do you have the Articles of Confederation?
We don't have the Articles, although we do have lots of discussion about the Articles, and we have Aristotle and Cicero,
right,
and the Five Knights case. We really lay the foundation well.
So do you need, from the evidence of your own textbook, I guess you conclude that you probably think you do. Do you need a theory before you become a lawyer? Is there something outside the law, then some teaching, some political philosophy that you really have to have in order to be a conscientious lawyer?
Well, I don't think this is unique to the law, because education can always be used for good or ill. And so you have to have some understanding that would allow you to distinguish between good and evil, but good and ill, so that you use the tools of your education, whatever they are, toward good. And that would be as true in the medical profession, we see reflected in the Hippocratic Oath, for example, as it is in the legal profession. And we've lost that.
I thought it was the hypocritical oath in the legal profession.
The Hippocratic and the hypocritical, yes. No, herein lies the problem.
Yes, right. Well, but which theory do you need then? I mean, since Montesquieu and Locke and Aristotle don't agree on everything, you throw them all in to the salad, or is there in fact a core that you think lawyers should focus on?
I do think there's a core, and we intuitively know it. And so the foundational education I'm talking about is to kind of awaken what we already intuitively know. And Cicero talks about this. You have this intuition about good and bad, and the good law helps to advance it. And it allows us to distinguish, for example, a regime, as our professor Harry Jaffa has taught us, a good regime and a bad regime. Well, if you just say that whatever the law is becomes good, then there's no such thing as a bad regime. And Nazi Germany is no better or no worse than the United States of America. And we all know intuitively that's not correct.
Mm-hmm. And Nazi Germany needs lawyers, presumably, just as any regime needs lawyers that has a positive law. Right. But is it the case that the knowledge that you impart can be incorporated into a casebook, as you have done? Is that adequate, or is it? I mean, one could devote a lifetime to the study of those texts and of the difference between right and wrong, as many people have.
Right. No, and certainly in a textbook in a single class in constitutional for law, for example, you're not going to get to that level. But I do think it's important that you lay the groundwork for them to ask the questions. To see, for example, the difference between a Hobbesian view of the law and a Lockean view or Montesquieu view. And in that seed, they start to develop that there are some limits on the exercise of governmental power that exist prior to the structures of government. And understanding that foundation, I think, is critically important. In this country, it's critically important to how we understand our own Constitution. And it's reflected in fights we have among conservatives on the court, between Justice Thomas and Justice Scalia, most notably, for example.
No, right, and I think we will talk about that. Does the kind of instruction that your textbook, your casebook, contains modify the usual approach to the law, which is case by case, the case method as it came to be called, which wasn't the way law always was taught in the United States. I mean, that was an innovation from the late 19th century.
Right.
You don't go all the way back, apparently.
Well, we do keep a lot of the case method, but the first couple of chapters, there's hardly a case in it.
Yeah.
We have passages from Aristotle. We have the wonderful natural law passages from Cicero. We have the distinction between Locke and Hobbes that comes out. And so people understand the foundation. So when we get to the early natural law cases that the Supreme Court decides, the language that the court uses, not pointing to a particular text, but pointing to overarching principles of justice, it's now more familiar to the students than it would have been. It would have been foreign without that preliminary material.
I see. So the idea is to make the court's language resonate,
indeed,
in the mind of the student. But if a student doesn't have the good luck to read your casebook in constitutional law and read one of the many, many other casebooks that are out there, is he disabled from being a good constitutional scholar and lawyer? Yeah,
one of the things you find with most modern casebooks and the teaching of constitutional law more generally is very court-centric, and you accept a premise that I think the founders would have strongly contested, that the court is not just the final say on interpretation of the Constitution, but the only say, and one need look no further than what the latest court pronouncement has been. And so the Constitution, the study of the Constitution, becomes largely separate from the text.
The Constitution is what the court say it is.
The Constitution is what the court say it is, so why study the Constitution itself? Why not study the most recent decision of the court? And increasingly that became the norm. And so by the 1970s, even having a copy of the Constitution in the text became superfluous. And I think our undertaking was to revive the notion that you can assess the correctness of the court's decision only by looking back at the original understanding. And that movement kind of took root in the 1980s and now has become fairly pronounced in the courts. At least they have to give deference or fealty to it, whether they comply or follow it faithfully or not. And that's a rather dramatic change from where things were 50 years ago.
Lino Graglia wrote a famous piece on how the Constitution disappeared from constitutional law. But it sounds like you could write one on how natural law disappeared from constitutional law. How did that happen?
Well, it happened. One of the most brilliant and devious justices ever sit on the Supreme Court was Oliver Wendell Holmes. And he writes this book in the 1890s called The Common Law. Which really redirected the common law. The English common law was really an attempt by judges to ascertain the higher law or the natural law. Holmes said, no, the common law is just judges exercising their will. We've got legislatures that pass statutes and we judges that issue judgments. And there's no difference between the two. There's no effort to seek out the higher truth because there is no such thing as the higher truth. That book becomes governing principle of the Supreme Court in a case called Erie versus Tompkins, which Justice Holmes writes. And it throws out the natural law as the foundation for our understanding of law.
But I mean, typically, right, the common law is distinguished from constitutional law to begin with. There are two different systems of law, two different kinds of law. How does Holmes's argument migrate from a treatise on common law, which is, you know, a British subject, or at least originally, to the province of our constitutional law?
Sure. So there were always two aspects of the common law. There are sets of rules that need to be put in place. Mm-hmm. For example, when we invented the automobile, who goes first when both come to an intersection at the same time, the person on the right or the left? Well, right. It turns out there's no natural law answer to that question, but you do have to answer it, right, because, you know, somebody's going to be responsible for causing an accident with another and have to be held accountable in tort. And so the legislature hadn't passed the rule yet, and yet there's an accident that occurs, and it comes before the court, and the court has to decide who's going to be liable, and they make a rule. Now that's one. It's filling in the open spaces of the law. That's one part of the common law. The other part of the common law was the judicial search for these eternal truths, and somebody that willfully causes a wrong ought to be held liable is of that nature. Holmes collapses the two. And says all of it is filling these interstices of the law, and it's just judge-made law. And then he comes up with this sleight of hand, and he says, and because it's just the lawmaking power, the federal courts have no ability to search for the higher truth because there is none. And in implementing the Constitution, they have to comply with whatever the state judges have said is the state law. And in deference to the states, they now obliterate the common law, the natural law, from any notion of constitutional interpretation. And not just in state law cases, but in any constitutional case, we no longer look beyond the raw positive law to find more timeless truths in our constitutional adjudication. And that's all a direct result of Holmes.
And so he's stealing a base there.
He is stealing a base.
Or at least maybe several.
Yeah, exactly.
He's a good base stealer.
That's right. Off of a foul ball.
Now, should young lawyers have heroes? And if so, should they be writers like Holmes? Should they be judges, justices? Should they be political figures? What should whom should if anyone, should young lawyers look up to?
Yeah, you know, we've had a couple of phenomenally good lawyers who became statesmen. James Wilson from the founding era, and a lawyer that wanted to understand the real depth and profound nature of our constitutional system could really do well to study Wilson's writings on it. Lincoln, a country lawyer who made good.
I thought that was Sam Irving.
You know, and had a normal business commercial practice, and yet saw, even in those disputes that he had to deal with to take on clients, a deeper meaning of the law, and developed an understanding of the Constitution that was truly profound and that carried the day at one of the greatest crises in our nation's history. So those are two great examples. Yeah. On the court itself, we haven't had a natural law jurist over a century, but for a couple of them. And so the couple that we've had are worth studying. George Sutherland from the New Deal era, and Clarence Thomas, and maybe Sam Alito today. And their writings, both before they got to the court, but since they've been on the court, are worth studying and emulating as well.